Order call the State versus Jacob Zuma and another.
This is for judgment on the special plea. I've prepared a written judgment comprising of some 287 paragraphs and 107 pages. Hard copies of this judgment will be made available to the state and to the defence when I adjourn these proceedings. Electronic copies of the judgment may also be obtained from my registrar after the judgment has been delivered. The judgment essentially consists of 5 parts. The first part deals with the introductory aspects and the procedure that was adopted in this matter for the adjudication of the special plea. That is dealt with in paragraphs 1 to 9. The second part deals with the events that have transpired, directives that I have issued from time to time, and adjournments that were granted from the time that the proceedings commenced before me on the 17th of May 2021, and include, where these were not previously given, my reasons for these various directives and orders. That is paragraphs 10 to 64. The third part contains the core of the judgment and deals with the meaning to be assigned to the words title to prosecute, and more specifically whether should be assigned a narrow or a wide meaning. That's in paragraph 65 to 132. The fourth part considers the alternative argument based on a wider or extended meaning of the words title to prosecute, and that is in paragraphs 133 to 286. And then the fifth and final part records my conclusion and the order, and that is in paragraphs 287 and 288. I provide the following short summary of the main findings of the judgment. This summary is not a substitute for the judgment, but it is a short statement of my primary findings, but without the legal reasoning. The issues are essentially conclusions of law. The primary issue in this matter is whether Mr. Dana has the title to prosecute Mr. Zuma on the charges contained in the indictment. Mr. Zuma challenged Mr. Dana's title by entering a special plea in terms of section 106(1)(h) of the Criminal Procedure Act, contending that Mr. Dana has, and I quote, no title to prosecute, unquote, him. That is the sole basis upon which Mr. Dana's removal as prosecutor was sought. There is no separate substantive application before this court, as for example had been the case in Porritt and another versus NDPP and others, upon which Mr. Dana's removal is claimed. Mr. Zuma's case is confined to the provisions of section 106(1)(h) of the Criminal Procedure Act, and that is accordingly all that needs to be considered. The basis upon which Mr. Zuma contends that Mr. Dana should be removed was explained in his plea in inter alia the following terms, and I quote, "There are facts and circumstances involving the conduct of Mr. Dana SC and the NPA generally relevant to the protection and interpretation of my rights under section 35(3) of the Constitution, for which it is necessary that Mr. Dana SC be removed as a prosecutor in this case. Further, Mr. Dana has failed to uphold the standards of prosecutorial independence and impartiality needed to ensure that my trial is fair and conducted in accordance with the Constitution and common law. In addition, it was alleged that Mr. Dana had played a role that makes him an essential witness on the issue of whether there was political interference, the nature of which violates my fair trial rights. And then in conclusion, a repetition that Mr. Dana is in a position of a prosecutor who is neither independent nor impartial, and that he feared that he would not enjoy a fair trial. The specific grounds advanced by Mr. Zuma in support of those contentions, and to which his counsel confined the argument, are 14 grounds, 12 of which were identified in the state's heads of argument, and then a further 2 grounds which were raised for the first time in the supplementary evidence affidavit. These are recorded in paragraph 67 of the judgment. As is apparent from the above plea, which I've quoted in brief terms, and by the grounds advanced in support thereof, the fundamental basis upon which Mr. Zuma seeks to advance the argument that Mr. Dana has no title to prosecute is that his rights under section 35(3) of the Constitution are threatened, that Mr. Dana is neither independent nor impartial, and that he, that is Mr. Zuma, will not enjoy a fair trial. It is not in dispute that Mr. Dana is properly appointed and authorized in terms of the Constitution and the provisions of the National Prosecuting Authorities Act to prosecute of Mr. Zuma. The central issue is whether the alleged lack of independence and impartiality, or Mr. Zuma's concern that he might not enjoy a fair trial, will negate the title to prosecute, which Mr. Dana would otherwise enjoy. The central question is therefore to determine what is meant by the words, quote, title to prosecute, unquote, in section 106(1)(h). I've concluded on an interpretation of that provision that title denotes standing, as in locus standi, that is a legally recognized interest, which, for example, a private prosecutor in terms of section 7 of the Criminal Procedure Act, or a statutory prosecutor in terms of section 8 of the Criminal Procedure Act is required to have. Such standing or interest, which a private prosecutor or a statutory prosecutor is required to have in the subject matter of the charges they prosecute, is incompatible with the notion of them being independent and impartial. If a lack of independence and impartiality would deprive a public prosecutor of his or her, quote, title to prosecute, unquote, then very few, if any, private and statutory prosecutors, by the very nature of the interest or standing that they are required to have to prosecute in the first place, would have the title to prosecute. Section 106(1)(h) does not discriminate between public prosecutors on the one hand and private and statutory prosecutors on the other. It applies uniformly to all prosecutors. It is unqualified in its terms. By parity of reasoning, I accordingly conclude that, quote, title, unquote, in the case of public prosecutors, similarly, as with private and statutory prosecutors, cannot be negated simply because a prosecutor might not be independent and impartial. The aforesaid interpretation of the word, quote, title, unquote, is also consistent with the decision of the Supreme Court of Appeal in Porritt, where, with reference to and quoting from the judgment of the Constitutional Court in S versus Sheikh, in regard to allegations that prosecutors in that matter were not independent and impartial, it was said, and I quote again, "The protection of an accused person therefore lies not in a general standard of independence and impartiality required of all prosecutors, but in the right to a fair trial entrenched in section 35(3) of the Constitution," unquote. The ultimate question to be answered is therefore not whether the prosecutor is not independent or not impartial or biased or not sufficiently independent or impartial, but whether the accused ultimately will receive a fair trial. Whether a fair trial is to be received is a question for the trial court to determine and decide when it decides or determines that it is appropriate to do so. But these considerations do not affect, quote, title to prosecute, unquote. In the Porritt matter, which I referred to earlier, the prosecutors were sought to be removed on the basis that they were perceived to be biased and would not serve impartially and carry out their duties without fear, favour or prejudice. In other words, the removal of those prosecutors was sought on grounds similar to those relied upon at present in this matter by Mr. Zuma. The SCA confirmed that the removal of the prosecutors on those grounds was not grounded on a lack of title in terms of Section 106(1)(h) of the Criminal Procedure Act, and that the appellants were therefore also not entitled to demand an acquittal. The rationes juris or decidendi, that is, the reasons for the decision in Porritt, being from a higher court, are binding on me, even if I had to conclude that they were wrong, which I don't. Allegations of bias, a lack of independence and impartiality, and any feared infringement of fair trial rights are accordingly not to be decided under the rubric of a special plea that the prosecutor has no title to prosecute. Title to prosecute is confined to the locus standi required of prosecutors and the regularity as regards their appointment or any additional authorization that might be required. In this latter regard, I'm thinking, for example, of the provisions of the Prevention of Organized Crime Act, which requires special permission or consent and authority in respect of racketeering cases. What an accused cannot achieve is to challenge an alleged lack of independence and objectivity or bias or a similar complaint under Section 106(1)(h). Any challenge involving an alleged lack of independence and objectivity or bias or a similar complaint, as alleged by Mr. Zuma, should have been raised in a substantive, separate application for the removal of the prosecutor. Such an application had apparently been pursued in Porritt and was, by agreement between counsel in that matter, considered before the Supreme Court of Appeal, but dismissed on its merits. Similarly, in the matter of Smythe, being the example mentioned by the Supreme Court of Appeal, I beg your pardon, as an instance where a prosecutor can be disqualified on the ground of bias or an apprehension of lack of partiality, was decided on the basis of a separate application. In the present matter, there is no such application before this court for adjudication. The sole issue, as I said at the outset, is whether the special plea in Section 106(1)(h) has been established. I conclude that Mr. Zuma's complaints, even if taken at face value, do not affect the, quote, title, unquote, given its correct meaning in Section 106(1)(h) of Mr. Downer to prosecute. I also conclude that there is no basis to assign a wider meaning to the word, quote, title, unquote, to include instances of a lack of independence and impartiality or bias on the part of a prosecutor by developing the law in terms of Section 39(2) of the Constitution. There is no need for such development, as adequate remedies already exist in our law to cater for the situation where the fair trial rights of the accused would be infringed or threatened. The special plea therefore falls to be dismissed. Accordingly, the provisions of Section 106(4) also need not be considered any further. In the alternative, and from paragraphs 133 to 285 of the judgment, I consider the position, should I have been incorrect in construing the reference to the term, quote, no title to prosecute, to not extend to a wider meaning, to include complaints of bias, lack of independence, and impartiality, or that the issue before me was not confined to the special plea, but also included an application for the removal of Mr. Dana as prosecutor. The judgment in this respect speaks for itself and requires no clarification. I consider myself to be bound by the findings made by the Supreme Court of Appeal in inter alia the spy tapes judgment, and also that of the full court of this division in the permanent stay application. That is, if Mr. Zuma was not in any event stopped from challenging issues arising in the special plea which had previously been decided in those earlier judgments. To conclude in regard to the 14 specific grounds raised, commenting on each individual, that many were based on speculation or suspicion, or are based on inadmissible hearsay evidence and not on fact. Even if in limited instances they might at best qualify as possible irregularities, these irregularities were not such as to require Mr. Dana's removal as prosecutor, and did not deprive him of the title, even in the extended sense of that word contended for by Mr. Zuma, to prosecute. The 14th ground advanced, namely the alleged unlawful attempted physical examination of Mr. Zuma, raised the issue of the proper interpretation of paragraph 3 of the order which I granted on the 10th of August 2021. In paragraph 3 of that order, I had directed, quote, that the state may appoint a medical practitioner of its choice to examine Mr. Zuma and, if necessary, to give evidence as to his fitness to attend court and stand trial, unquote. An argument was advanced on behalf of Mr. Zuma that this order was somehow linked to a medical report by Mr. Zuma's doctors first being produced. I have clarified in my judgment that the order which I granted was unconditional and not qualified in that way, and that Mr. Zuma was required to submit to medical examination by a doctor or doctors of the state's choice to determine whether he is fit to attend court. My clarification of that order is contained in paragraph 284 of the written judgment. The written judgment accordingly concludes with the following order being granted. 1. The special plea is dismissed. 2. The matter is directed to proceed to trial in respect of the not guilty pleas of Mr. Zuma and Thales. And 3. Paragraph 3 of the court order of 10 August 2021, as now clarified in paragraph 284 above, stands. That is my judgment summarized in respect of the special plea. Mr. Dana, what I require is a date for this matter to be adjourned to. I do not know. Have counsel considered that contingency if the special plea was to be refused?
My Lord, I have
whether a suitable date has been.
I have discussed it with accused number 2, Thales, Mr. Roo and Ms. Jackson, and the current situation is that the state is ready to proceed within a reasonable time.
Yes.
And that is within the next 2 or 3 weeks.
Yes.
So we've looked at the dates, and the 15th of November would suit the state.
Yes.
Apparently that does not suit accused number 2, Ms. Thales, because of availability issues.
Yes.
I'm informed by my learned friend for accused number 1, Mr. Masuku, is now
I see
here
Mr.
in court.
Masuku has now arrived.
Yes, so I haven't had a chance to talk to him, and my learned friend asked me if we couldn't adjourn so that we could have discussions between counsel.
Yes.
But we might...
How long will you require, Mr. Dana? It's
probably...
now half past, well, what is it? 20 past 10.
Yes.
Shall we resume at quarter to 11?
Quarter to 11, perfect, my lord.
Will that
yes.
be enough?
I think that
If you
would be
require
enough.
more time, then please just contact my registrar. But I think let's try and identify a date, certainly, that suits everybody, so that the merits can be ventilated.
Indeed, my lord. My lord, we might need some guidance from the court if the date, for instance, of accused number 2 is very far in advance, whether that would be acceptable to the court. But perhaps we'll deal with that when we discuss the dates.
Yeah, it's we're heading for the end of the year, which is always a bit of an awkward time.
Yes.
And there is some distance involved here. But yes, well, I think let's not preempt it.
Indeed, my lord.
Let me not comment on it for the moment. It's obviously in the interest of all the parties, accused, the state, representing the general public, that this matter be resolved as soon as is reasonably possible. It's been hanging around too long. I think everybody needs certainty, one way or the other. So let's see whether we can accommodate it earlier,
I'm indebted to
or
the
at
court,
an early
my lord.
date.
Yes.
Mr. Masuku?
My lord, firstly, may I apologize for arriving late?
Yes, no problem.
I had difficulties coming to the court, which I can explain.
Yes, no, thank you for that. I accept it.
I'm grateful for that. The second issue, we would like to have the judgment that has just been handed down for the purpose of engaging with it, and then we'll decide where to go from.
Yes.
But
Copies are available.
we certainly going to engage with the state on the issue of when this matter can be postponed to, and I think the time frame that you've suggested is sufficient for us to come to some agreement.
Yes, you would have missed my opening comments possibly, where I said that I prepared a written judgment.
Yes.
And copies, hard copies, will be made available to you now when the court adjourns, and electronic copies will also be available through my registrar. So if you haven't caught all the parts of my summary, the written document is going to reach you soon.
It does look
Yes.
right.
We'll resume that at quarter 2. Court will rise. Yes. Ms. Jackson,
Yes, my lord.
you happy with that? Any other conditions you want to attach to it, Mr. Dana? We've been excusing Mr. Durant from past hearings. Obviously, he's got to be here on the 11th of April. But I think that follows, Mr. Jackson. We don't have to say anything about that. He's got to be back here. And Mr. Zuma is present, so he can simply be warned to be here on the 11th of April.
As previously, my lord, yes.
Yes.
Absolutely.
Yes. Very well.
And my lord, if just one other thing, if there should be any interlocutory applications between now and the 11th, can Mr. Zuma be excused until the appearance of the 11th?
Well, it will depend on the nature of the interlocutory application.
I'm just saying,
I think
there
let's-
is an interlocutory application that has nothing to do with the trial, but has to do with this matter. Could be an application for leave to appeal,
Okay.
or anything like that.
Well, I
Can he
think-
be excused from attending the trial
Yes,
until the 11th of April?
I think I cannot answer that question in the abstract. Depending on the nature of the application, and with input from the parties, I'm certainly not of the view that I want to simply inconvenience him and bring him to court if it's not necessary. So I think let's deal with that on an ad hoc basis, as and when they develop. You can approach me beforehand, before such an application is brought. If it's an application for presumably leave to appeal, then, well, I'll hear what the state has to say about that, but that's pretty much a cold legal argument.
Would
And I don't think-
you want
I don't
to
think-
hear on that day?
I don't, speaking for myself now at the moment without having heard the parties, prima facie, if he doesn't want to attend such an application, I wouldn't insist that he attends. But that is a prima facie view only. There might be compelling reasons that the other parties might want to advance, and possibly the way to deal with it, if there is going to be an application for leave to appeal, that obviously it be set down in accordance with the rules, and that my registrar then be contacted. Just indicate, the state in particular, I don't think Ms. Jackson will necessarily have a problem, whether they insist that he attends, and I will then make a ruling. But prima facie, and I don't think I can do more than that at this point, for leave to appeal, I don't see a difficulty.
Well, I think it was complicated, but I understand, Malik.
Yes. Now, I just don't want to the door without hearing all the parties. I think we must be transparent on that.
The agreement was that we were going to postpone the matter for trial
Yes.
to April. We understand that Mr. Zuma has to be here only for the trial
Yes.
in April. I was simply pointing out the possibility that there may well be interlocutory applications in between.
Yes.
And I was trying to point out that nothing to do with the date on which he is expected to be here. And I was trying to get to understand whether the bench would insist that he be brought to court, irrespective of what application he is bringing
Yes.
for that time. But I understand if you...
Yeah, I don't think it's appropriate to give a blanket sort of okay to any application. But I've made my views, I think, my prima facie views clear in regard to an application for leave to appeal. But let's deal with it as ad hoc when it develops.
Okay.
Yes. This matter then is adjourned to the 11th of April 2022 for trial, set down for starting on that day and for the 2 terms thereafter. And Mr. Zuma is warned to be at court on the 11th of April 2022. And the representative of the second accused must obviously be present on that day. And the previous dispensation where he was excused would no longer apply. That concludes the business for today.
Please, court.
Yes. Court will rise.